All right, let's go on the record. Mr. Clark, if you could announce your name and the cause number of the case.
Well, it's a pretty simple name, Robert Clark, and I represent Nori Niven as the defendant in this case, and we're ready to see. We would like a
not yet. Mr. Kettler, go ahead and make your announcement and announce the name of the case and the cause number.
Your Honor, John Kettler on behalf of Plaintiff Portfolio Recovery Associates, LLC, the cause number being DC-19-11445.
All right, let's go ahead and begin with opening statements. You may proceed. Mr. Kettler.
Your Honor, this is a debt claim lawsuit in the amount of $64,622.43. On or about 1992, the defendant, Nori Niven, opened an account with Citibank due to a period of non-payment, with the last payment being on or about December 3rd, 2017. The defendant had defaulted on the account, and on or about August 17th, 2018, the original creditor, Citibank, had assigned their account to the current plaintiff today, Portfolio Recovery Associates, and they're currently the holder of this account. We're respectfully moving for the amount that has been sued for, the $64,622.43, as well as cost of court and any other relief.
Mr. Clark?
Yes, Your Honor. We filed our answer on this case on September 20th, 2019. We requested disclosure. They've given us none. They're not going to, we believe they'll be, we would object to them putting any of the evidence that you just heard from this opening statement into evidence. Secondly, we sent requests for admissions, and it's admitted 12 different items. They never responded to that. They had sent discovery with their petition. We answered that, and they have not answered any of the admissions nor disclosure. Any of those things that Mr. Kettler said are not evidence unless they can introduce those. And actually, they're foreclosed to bring up anything. I'm only saying this because we've got some associates, some interns here. And so I'm going, because I know, Judge, you know the rules on this. They admitted that that neither you nor assigners provided any goods or financial services to the plaintiffs. They've acknowledged that they cannot produce any account statements, and yet they've produced them and mailed them in to the courts. They haven't answered nor moved to for admissions. We put in the pleadings so that the other side cannot get a new lawyer and someone who's never made an appearance in this case and said, well, where's their proof that they sent it? So we put it in our answer. It's e-filed. They received it. They've obviously responded to us as late as filing motion for continuance on the eve of trial after waiting, 8 or 9 months. This is a type of fallow case that should be disposed of.
Mr. Clark, so if I understand it, what you're saying is that you sent them discovery and they've never answered it. Is that right?
Yes, but it's deemed admitted.
Including admissions.
Yes.
All right, Mr. Kettler, what is your response to that? That's obviously a concern.
Well, on my review of the file, I've shown that on or about October 18th, 2019, Ms. Madeline Hayes had signed off on submitting discovery responses to these disclosures and admissions that Mr. Clark is mentioning. So are showing these discovery requests responded to?
Can you go ahead and share screen those? I'll go ahead and enable that.
Beg pardon, Your Honor. I've got this pulled up on a laptop and I've got my Zoom set up right here. So if there's any other way that I could submit this to you, could I submit this to Rhonda?
So just share screen it. If it's on your laptop, you should be able to share screen it.
Oh, but Your Honor, the Zoom conference is on my phone right now. So I can't.
Oh, I get it. Okay.
Your Honor, what we did when we sent this, we send it, we have an attachment that goes when we file this with the records. I heard the language very, very precise. He said it was signed off on by a lawyer or something like he said. They should have a receipt. I'm showing something that perhaps people can see. This is attached whenever you file something. Or I suppose if they do it the old-fashioned way, they'd have a fact sheet when they sent it or something to show that they had delivered this to us. I'm here to state that they did not deliver us to this. Do they have any kind of receipt that they?
Rhonda, why don't we do this? Rhonda, share in the chat function your email address, and then go ahead, Mr. Kettler. Immediately email her the this whatever you're talking about, this response. And Rhonda, have you shared that yet? You need to type in the chat.
Your Honor, I believe I have Miss Rhonda Pinson. I believe I have her email on file.
Okay, go ahead and email her immediately this information, and then Rhonda, go ahead and email it to me, and I'll share screen it. Are you emailing it, Mr. Kettler?
Yes, Your Honor. I'm going to go ahead and label the subject current trial.
Okay. And also email Mr. Clark, whatever you're emailing us.
Yes, Your Honor. I'll go ahead and forward that to Mr. Clark right now.
And this of where they sent it, not just.
Why don't we do this? I'm going to take a quick 5-minute break. So if you, wait a minute. Is this it? Okay, never mind. I got it.
Sorry, what email did Mr.
Mr. Clark, you were asking what it to?
Was it done by US Mail?
Was it RMC at robertmclark.net?
.net. And we have received it. It doesn't have a green. I'm sorry. We still. Yeah. It doesn't have a green card. They sent it by US Mail. All
right. Can you guys see this on the screen? Their certificate of service. Can you all see it on the screen?
Your Honor, I emailed it had been sent, but I don't see the attachment pulled up.
Okay, so let me try this again. Okay, let me try again.
Signed green card in my office. Obviously, we sign those every time they come in.
All right, can you see it now?
Yes, Judge.
And it says there's this. It says via signature confirmation 7019. Certificate of written discovery. And here's the answers. It looks like they did send you answers.
Well, it looks like they attempted to, we never received it. And they don't have a green, the reason, Judge, with that, they send a green card with that, and they would have that by now because that was months ago.
But it has a signature confirmation. Isn't that 70190160000083945647? Is that the green card number, Mr. Kettler, or what is that number?
Your Honor, that should be the certified mail return receipt number.
Yeah, that just shows that they're saying they mailed it. That's from them. We never got it.
Okay, I'm trying to look at this. So it looks like they're just going to call the plaintiff's records custodian. There's really nothing else in here. So, all right, I'm going to go ahead and allow them to go forward. I think this is sufficient evidence to show they answered discovery. So, Mr. Clark, did you have anything else before we start with witnesses?
Let's see. No, not in my opening, Judge.
Okay. Mr. Kettler, call your first witness.
Your Honor, we don't intend to call any live witnesses today. However, I would like to respectfully request to take judicial notice of everything on the file, including the business records affidavit filed timely for this case today. And if you'd like, I can go ahead and brief rundown of what's included in that business records affidavit to prove up.
So let me make sure, because I want to share screen this. This was a document you filed with the clerk. Is that correct?
That's correct, Your Honor.
All right, so give me a second to pull that up. I wish I could do this immediately, but it's a little bit slower with the system.
Judge, if I could respond, I'm going to object to Mr. Kettler testifying.
Mr. Kettler, you're not going to be allowed to testify.
And that means him describing, that'd be final argument, I guess, would be what he's talking about.
I think that's true. Let me go ahead and find out when was this business records affidavit filed?
Your Honor, this business records affidavit was filed 2 weeks in advance for the 14-day requirement rule on June 23rd.
I see the notice. Let me just see what this says.
My phone?
Yeah, I see it in the system. I just can't pull it up for some reason. Let me try again. And you can't share a screen, can you?
I can't, Your Honor, but I can send Ms. Pinson an email with the document that appears on the Tyler Odyssey portal.
Yeah, why don't you do that? That may be quicker. For some reason, I can't open up the Dallas County document here.
I'll go ahead and send that to Mr. Clark as well. And this is me directly downloading the file from the Tyler Odyssey portal.
I see it in the portal. I just can't open it for some reason. Mr. Clark, did you get a copy of this?
We got the business records affidavit. They did it twice, 4/10 of 20. They submitted with no answers to discovery, but a business records affidavit, and then they filed a second business records affidavit on 6/23 of 20 is what our records show.
Okay, let me see. Rhonda, have you gotten that yet?
We had that for, but we didn't want it. We didn't print them.
Did you send it?
I did, although it was a very large file, so if there might be a chance that there's some issue with it.
Oh, it looks like I got it. Let me see.
Okay, great.
No, sorry, wrong doc. No, that's not it.
Should lead off notice of filing a business records affidavit.
Here it is. Okay.
Perfect.
Okay. So does this actually have the, it looks like you sent me the file transfer. Does it include the attachment on it or not?
It should include the attachment, Your Honor. I attached it to the email. Again, it's the same what's on the Tyler Odyssey portal right now.
Let me see. Does it require me to have an verify access pass?
I'm not sure, Your Honor. I didn't show anything suggesting that.
Call from
Let me see. Whatever you're trying to send me is it's not working. Let me see if I can just open this on the system.
Your Honor, if I may, it sounds like between the Tyler Odyssey portal and maybe the size of the file, I've got one idea that might be able to work for us. I could compress it or divide the file real quick with a brief 3-minute recess or so.
And there's another way I can do this too. That might work. So what I'm going to do, I also might be able to, I'm on a laptop and I might be able to open this on Odyssey. So let me, let you try to do that, and I'm going to try to get onto Odyssey. I'm not sure this is going to work, but
And whoever gets wins, Judge.
so let me try to open that real quick. So you try to do that, and I'll try to do this. Let's see. And if Mr. Ralston, if I may lose the connection to Zoom, so if I do, I'm going to make you the host. Did you hear me?
Yes, sir.
Okay, you did that yesterday, right?
Yes, sir.
All right, that's going to be your job now. So, do you know how to do it? Tell me if you lose me. Julie, go ahead and text me if you lose me off of Zoom. Can you guys still see me on Zoom?
I can see you, Judge.
Okay, let's see. Huh, let's okay, I can see the notice of business records filing.
Is it a 50-page?
Okay, so Mr. Clark, are you there? Mr. Clark, are you there?
I am now. I had it muted. Sorry.
That's okay. So you have a copy of, I can see it now. You're going to need to go ahead and email this to Tony, who's my court coordinator, court reporter, so that she can make it. So you're going to offer this as Exhibit 1?
Yes, Your Honor.
Any objection?
Yes, Your Honor. The business records affidavit, I'm looking at paragraph 5 of that. There's no personal knowledge of any of this. I am similarly aware by personal experience and by common knowledge. And common knowledge is not a way that someone can get something in a business, confidential business record. The personal experience, and that's highly conclusory. So the number 5 of the records affidavit, and then you go to the next, see, there's an assignment there from Citibank NA, and which I think is a different name than what is in the card records, and which would raise a standing issue, which doesn't even have to be raised till time.
Let's deal with these one at a time. Mr. Clark raises an important point here about paragraph 5. It doesn't appear like that satisfies the business records requirement exception to the hearsay rule.
Your Honor, we would like to show that this document, this business records affidavit, meets the substantive requirements of the rule, where it meets the form and the substance of required. So this individual is attesting to what they know, and that's based off of the document that the individual has on file with portfolio.
Okay, you cut out there. I didn't hear what you said. You said something about you're going to call this person live. Is that what you said?
Yeah, no, Your Honor. We're just wanting to clarify that this business records affidavit does meet the standard under the rule, the exception to because it meets the substantive requirement of the document. So even if there is some whole paragraph I may have an issue, the overall document successfully establishes that these are business records that belong to Portfolio Recovery Associates and that the applicant is aware of.
I don't think this qualifies. Let me do this. I'm going to go ahead and grab I don't have my rule book right with me. Let me go grab my rule book, and I want to compare the language.
And, yeah, my objection is hearsay.
That is really mean. That smells really good.
Mr. Kettler.
Yes.
This is the reporter. Is there a way you can maybe pull your microphone closer or something? I don't know, but you keep cutting out. And so I want to make sure that I get everything that you're saying, but some of your words are cutting off. Okay, thanks.
Can you hear me better now?
Yes.
Perfect, thank you.
I mean, this is a common problem with these types of cases. I'm back, guys. Okay. So I think this is under 8036, correct? Let's see.
Yes, Your Honor.
I don't see how this qualifies under 8036 with this language. Do you have any case law to indicate that this would qualify?
Your Honor, I do not have case law that would show that it would qualify.
Okay.
While you were away, Judge, I put on the record objection hearsay. So.
Okay. So there's a case in O'Connor's, and then I know there's a lot of cases on this topic. But it's this is someone from Portfolio Recovery Associates trying to prove up the records of, was it Bank of America? Is that right?
Original creditors, Citibank.
Citibank, sorry. In Savoy versus National, Savoy is SAVOY versus National Collegiate Student Loans Trust, 557 Southwest 3rd, 825. Says a document authored or created by a third party may be admissible as a business records of a different business if A, the document is incorporated and kept in the course of the testifying witness's business, B, that business typically relies upon the accuracy of the contents of the document, and C, the circumstances otherwise indicate trustworthiness. I don't see how this affidavit satisfies that case. And there's cases out of Dallas too on this topic, but I'm not 100%, I'm not up completely on they've kind of gone back and forth on this. So nobody has any case law on this?
Your Honor, I have not rested. I would like to respectfully non-suit this case without prejudice as to the refiling.
Okay. Mr. Clark?
I guess he said he had no witnesses and this is his only exhibit. He has not rested, so I'm not clear whether it's attached or not.
I'm pretty certain that he has the ability to still non-suit, but let's look that up real quick. Because I know that usually is when it goes to the jury and he hasn't rested. So I think he's right that he can non-suit this case.
And Judge, I'll do a case on that. I can't find the exact language, but Hooks v. Fourth Court of Appeal. I can, if you'd like me to, I can bring this. Go ahead.
I'm looking it up. I'm pretty sure you're right, but
I think Mr. Kettler is right, but I wanted to raise that because he did say he was not calling any witnesses, and this was his only document. So
I don't think he hasn't rested yet.
He hadn't officially rested. Yes, sir.
A non-suit in a trial must be taken before the plaintiff introduces all of his evidence other than rebuttal, i.e. before it rests. And that's Epps v. Fowler, EPPS v. Fowler, 351 Southwest 3rd, 862, Texas Supreme Court, 2011. Also In Re Team Rocket, LP, 256 Southwest 3rd, 257, 259, Tex 2008, another Texas Supreme Court case. And there's actually two other Supreme Court cases that indicates that this is permissible. So unless Mr. Clark,
yeah,
I'm sorry.
briefly, Judge, I think what he said is this was his only evidence. Now, it says after he introduces all his evidence, and he hasn't really been able to introduce any evidence. So,
Yeah, I don't, he hasn't rested. He was in the middle of trying to introduce this evidence, and it wasn't resolved. So I think he's timely, unless, you know. So I'm going to go ahead and allow the non-suit. I want to remind you that if you refile this, you need to indicate that this is a related case. Yeah, so I think he's fine. Rhonda, if you could go ahead and prepare a non-suit order for me on this. And Tony, did you get the non-suit on the record?
I did, Judge.
Judge, Your Honor, this is Mr.
Yes.
Clark. Since we have all these interns here, maybe you could and instruct me and maybe Mr. Kettler on the service of something when they send it and don't have a green card. Is the green card superfluous, or I'm just trying to figure out, because obviously if it had been emailed, we would have easily got it. That's how most things are sent to me now. And so someone signs something that they sent it, and
I feel like, Mr. Clark, you're still trying to argue this point.
Well, I'm trying to actually, no, I want to know that I won't even raise the not having the green card next time, because I have lots of, you know, I've raised in CLEs and things, your rulings, to try to double check so that I know, as an example, normally the first continuance, you know, we've talked about that, is always granted. I think under the pandemic, maybe that's modified based on what you said on some of the other cases. It's not just a throwaway motion. So I'm trying, so all these interns were here. I just wanted, so I've always argued that they don't have the green card, but you know, so it wouldn't make any difference because they didn't get the admission in. I'm just trying to know for other cases, or if I have another case with Mr. Kettler.
But the reason I decided on this particular case was that they had the green card number. I don't know how you would transfer electronically proof of a green card. I guess you could scan it or something, but they had the green card number, and so.
Okay. That's I'll know that, and I may cite that in other courts that if they don't have the green card number, that maybe it's not admissible.
You're going to cite Judge Hoffman in the other courts. I'm sure they'll appreciate it.
Some of the Tillery, I think he would probably accept it.
Yeah.
The others, newer judges might not. They don't want to hear that. I'm kind of going on, Judge, so I'm kind of kidding.
Mr. Clark, it was good to see you. Mr. Kettler, good to see you. And Ms. Clark, I think you were here too, but she may be gone now.
Yeah, that's my daughter. She just interned under Judge Tillery. Can I? She accidentally got pushed out. Can I get Mr. Kettler's mobile number? I may want to talk to him. Looks
Mr.
like
Mr. Kettler.
Well, since we're recording live on YouTube, I would prefer not to give out that number.
Yeah, let me turn
Okay.
off the
That's
YouTube.
I'll give